Great. Sorry about that. Technical difficulties. We're going to start a little bit over.
For the record, Ameren Daily Legislative Council.
Jen Carvey, Legislative Council.
So what I am screen sharing right now is draft 1.1 of S37. It's a markup version of a strike all amendment to S37 as passed by the Senate, an act relating to access to legally protected healthcare activity and regulation of healthcare providers. The language that you see in here is the Senate version of S37, except where there is highlighting. Yellow highlighting means we are proposing changes for your review this morning. The struck through language is language we're proposing be deleted, and the bolded yellow highlighted is language that we're proposing be added.
Great. So, like I said, we're here all morning. We're going to take section by section. I do want to get through all the sections. And we'll take breaks as we go. And so just know that we'll make sure we stop at times to give everyone a chance to stretch. So I'm going to start with you all.
So section 1 is the definition sections. These are 3 definitions that would be added to Title 1 as a new section 150. First, we have, this is a new section that would be legally protected healthcare activity. It would have the definitions for gender affirming healthcare services, legally protected healthcare activity, and reproductive healthcare services. The only change from the Senate version that you've already gone through is adding in the words including medication, so that first for gender affirming healthcare services, it would read gender affirming healthcare services means all supplies, care, and services of a medical, behavioral health, mental health, surgical, psychiatric, therapeutic, diagnostic, preventative, rehabilitative, or supportive nature, including medication relating to the treatment of gender dysphoria and gender incongruence. That was a question that came up during committee discussion last week about whether this definition would include medication. And so we are specifying that medication is included.
I think
It seemed inherent, but in order to be explicit, we included the language.
And I think it's just, well, let's keep going and then we'll stop after this.
There were no changes from the last time you reviewed the definitions to legally protected healthcare activity. And then when you scroll, I will scroll down to the third definition on page 3 for reproductive healthcare services, you'll see the same addition of including medication. To be clear that care does already include medication. Right. And upper.
I think it's important that just for us, so repeat the last sentence in section 1.
Repeat the last sentence.
Section
No, not
1A.
1A.
After you made the change of medication.
Yes, gender affirming healthcare services does not include conversion therapy as defined by 18 VSA section 8351.
Okay. Thank you.
Welcome.
Any questions or thoughts on this?
We have shared these updated definitions with Michelle, who you met with yesterday. She is working on markup with Senate Judiciary this morning. So in order to make sure we're being consistent.
On H89.
On H89. Okay, so that seems good.
Next, moving down to section 2, medical malpractice insurance. This is the section that adds in that would prohibit a medical malpractice insurer from adjusting the premiums. We scroll all the way down to the language itself. From adjusting or otherwise calculating a healthcare provider's risk classification or premium charges on the basis that they're providing legally protected healthcare activity, excuse me, that another state's laws create potential or actual liability for that activity, abusive litigation against a provider concerning the legally protected healthcare activity, resulting in a claim, settlement, or judgment against the provider, or the license of the provider has been disciplined in any way by another state solely based on the provider's provision of legally protected healthcare activity. There have been no changes to this section since you last reviewed it.
And this is where we did not take in-person testimony on this, but Jamie Fian, who represents, I forget, the insurers, provided testimony that they had worked on language in the Senate and they support the language that is before us. Give everyone a second to look at that. Any questions?
Yes, anything that Michelle was going. Does Michelle ask anything on this?
No, she came in yesterday and walked us through H89, which was a question on abusive litigation. So I think we're good. Okay.
The next three sections concern insurance and Medicaid coverage. The first, section 3, is coverage for gender affirming healthcare services. This would require health insurance plans, Medicaid, to provide coverage of gender affirming healthcare services. The coverage would need to be services that are medically necessary and clinically appropriate for the individual's diagnosis or health condition, and services that are already included in the state essential health benefits benchmark plan. This section says that Medicaid must comply with all federal requirements. Nothing in this section would prohibit a health insurance plan from providing greater coverage for those services than is required under this section. And in terms of cost sharing, a health insurance plan shall not impose greater coinsurance, co-payment, deductible, or other cost sharing requirements for coverage of these services than apply to the diagnosis and treatment of any other physical or mental condition under the plan. And there were no, there are no changes in this section from the last time we reviewed it.
Art?
I just want to be clear. Hope I can understand what percentage of our overall insurance coverage this applies to. I know we talked about it. This is the Medicaid piece, obviously. What beyond that?
Excuse me, beyond
And
that.
I don't need exact figures, I just want
Right.
to understand.
So this would be our fully insured markets. So that would be the small group and individual markets that are on the exchange, and also any reflective plans that are offered separately by insurers. And it would be the fully insured large group market, which does not include employer-sponsored health.
Okay,
plans.
so the only thing really not included is employee-sponsored.
It's a, that's a test. Don't worry about those.
Yeah. Yes, and any other federal insurance coverage.
Okay, so
Medicare,
That
there's
is
insurance for
not-
people who are in the armed forces. It
that
would not
insurance,
cover
I
those.
just want to be able to respond properly to it. Mill insurance. Okay,
Does it include state employees or teachers' health plans?
Yes, I'm sorry, it does also include state employees.
state
The
employees,
state
so,
employee
right,
plan.
correct, I
for
imagine
teachers.
so. Is there any place we could get kind of a chart or something on
I
this?
feel like Nolan has that, and the Green Mountain Care Board may also have that shows the breakdown of
Yeah,
the market we can regulate and the market we cannot regulate.
right. It'd be good to know it in this case because I think it's important.
Let me see.
Can you try and find it?
I will see if I can.
The Insurance 101
Yeah.
presentation that Nolan and I did towards the beginning of the session.
All right.
Has that information. And I also want to remind people that Blue Cross Blue Shield said they started covering gender affirming care in 2012, and that the essential health benefits benchmark was added in 2014. So this
Right,
is
but-
basically codifying what we already do.
Right, and I understand that.
Yeah.
I just want to know what that is now because we're spelling it out here.
So I'm going to let Jen find
Yeah.
that and just
Yeah.
email it to us if that's okay, or direct us to the link. Any other questions on this section?
The next section, section 4, is coverage for abortion and abortion-related services. This would require Medicaid and health insurance plans, including the state employees' health plan and teachers, to cover abortion and abortion-related care. For this section, the cost sharing is a little bit different than what you saw in the previous section. Coverage required for abortion and abortion-related services shall not be subject to any copayment, deductible, coinsurance, or other cost-sharing requirement or additional charge, except to the extent that such coverage would disqualify a high-deductible health plan from eligibility for a health savings account and for coverage provided by Medicaid. So those would continue to have cost-sharing, like copayments, deductibles, and cost sharing, coinsurance. There were no changes to this section since you last reviewed it.
Okay.
Section 5 relates to sort of an administrative step that the Department of Vermont Health Access would have to do in order, if they need to, they would seek approval from the Centers for Medicare and Medicaid Services to allow Vermont's Medicaid program to provide coverage consistent with this act. So we put that in whenever they might be making a change to their state plan, but given that they already had testimony that they provide this, we don't believe it's necessary. Put it in just in case.
And so just a reminder for sections 3, 4, and 5, we heard from Medicaid, Blue Cross Blue Shield, and MVP, and they were all supportive of this language.
What's the last thing you said? Oh, MVP, sorry.
Any other questions on those 3 sections since they kind of go together? Okay.
Next 2 sections relate to professional regulation, first from the Office of Professional Regulation, and then the second will be the Board of Medical Practice. So first, you'll see some new language here in section 6. Previously, this bill still had amendments to Title III, Section 129A, which is OPR's unprofessional conduct provisions within Title III. So the first subsection A is introductory language, so you can, is current law, so you can see where the changes fit in the next section. So in addition to any other provision of law, the following conduct by a licensee constitutes unprofessional conduct. When that conduct is by an applicant or person who later becomes an applicant, it may constitute grounds for denial of a license or other disciplinary action. So any of the following items or combination of items, whether the conduct at issue was committed within or outside the state, shall constitute unprofessional conduct. So first, subdivision 7, we're making some amendments to the current language. Currently, the language reads, willfully making or filing false reports or records in the practice of the profession, willfully impeding or obstructing the proper making or filing of reports or records, or willfully failing to file the proper reports or records. And then we're adding a new language, or willfully providing inaccurate health or medical information to a patient, including purposeful misrepresentation of a patient's health status. That is new. Would you like me to pause?
Yeah, so that'd be great. So just the highlight of yellow is language that's already in statute.
Yes.
The highlighted and bolded and underlined is what we're adding. And remind us why we're putting it here.
This was suggested language from the Office of Professional Regulation that you heard about yesterday.
Ellen, and then Art?
Just a confusing question, I guess. You know, it says willfully providing inaccurate health or medical information to a patient. That happens all the time. If you go to an eye doctor,
Yeah.
this one says you need an operation of this, you go to the second opinion, they say, no, you don't need this.
Maybe we need to just define willfully.
I think so.
For the, not in the bill, but just.
No, just for the purpose of conversation, not in the bill. No, purpose of conversation.
Yes, what willful is a legal term. It means intentional. So intentionally providing inaccurate information to a patient. Hopefully that does not frequently happen. There may be differences of opinion among providers about what is the appropriate course of treatment for a patient or diagnosis.
That willfully.
Well, right, so that's why it doesn't happen. I mean, there's a difference between providing information that a provider believes to be accurate but turns out not to be, and intentionally providing inaccurate information. So it's only the latter one that is that would be specifically within OPR's purview in this case. If somebody was consistently providing inaccurate information, there may be other other concerns for the regulators about their ability to perform.
Art and then Mari.
Yeah, I just wanted to know, this, all of section 6, will that all be in statute?
Yes.
It's all statute language?
Yes.
Okay, all right, thank you.
Art, and Mari and then Topper.
I was just going to add that in your concern about second opinions and differing opinions, there's decades of established precedents and in cases and cases within OPR and boards of medical practice and all the other organizations that review situations like this. So there are standards that include what any reasonable healthcare professional in this situation would do. So there's already like well-established
Well, I was hoping that was already in somewhere.
practices, yeah. It's healthcare, so you can imagine there's scads of history and practices around stuff like that.
And this applies to, and correct me if I'm wrong, licensed organizations or ones that become licensed.
This is licensed healthcare professionals that are under the purview of the Office of Professional Regulation.
And again, if they are unlicensed and doing things in the healthcare space that otherwise would require a license, there's laws on unauthorized practice.
Right.
Any other? Okay.
The next subdivision, 29, is new language, providing or claiming to provide services or medications that are purported to reverse the effects of a medication abortion.
I have a question on that.
Sure.
What if, well, first of all, I refute the claim that you can't do it because I believe you can't, but be that as it may, if technology increases and this can be done in a manner that suits the minds of whoever thinks about this, what happens to that piece?
It would remain unprofessional conduct until this law is changed.
Okay.
But there could be enforcement discretion, so that doesn't mean, just because it's in here doesn't mean if the science changes or the technology changes, OPR could choose to enforce against a particular provider.
Okay.
Which they do in various circumstances. I think we talked about that some in the past with out-of-state provider, somebody vacationing in Vermont and a provider, they call their provider back home and the provider gives them some medical advice, even though the provider isn't licensed in Vermont. And OPR has said, they exercise enforcement discretion. They don't go after that provider for unauthorized practice in Vermont. So they do have the option, the choice of whether they bring charges in any particular.
And I just wonder about the wisdom of having that in there. It just seems to me that the way things change, it's almost like saying you can't use the internet for something and 2 minutes later you can because things change.
So I know
I was specifying that
because
very specific service.
right now people are being told that it can happen and the medical industry is saying it cannot. And so people are being harmed. So we disagree.
Yep.
Bobby?
My question is in reference to arts, which is the word purported is the magic word in this particular sentence. Because purport, doesn't that imply deception? Like pretending? It's kind of like, I don't know, maybe that's why I'm asking.
It doesn't necessarily mean deception, or it's that there is differing opinions about whether this is a process that will have that effect of reversing a medication abortion. And the testimony that you've heard is that the medical community as a whole does not believe that it's confirmed that this could have that effect. So we're trying to get at the activity without saying it can happen or that it can't happen. But the idea is just that people are trying to, or saying they can provide something that there's differing opinions about whether it actually can be provided. So we're saying it's being purported to provide, suppose we could look for a different word, but I think for this instance, it's not meant to imply deception or untruth, but just it's purported to do this, whether it does or does not. We're not weighing in on that. We're just saying that for the time being, you can't provide or claim to provide something that purports to do this activity.
Is that a word that's frequently used in law, purported?
Sometimes.
Just curious. Okay, that's it. That's my question.
I have a question.
Thank you.
Is there not something, some kind of a medication that if you take it within a certain period of time, it can reverse?
That is not a question I could answer.
What there was.
No, there's no medication on the market that can do that. There's medication on the, like, Plan B.
Yeah.
That doesn't reverse an attempted abortion.
But it prevents
Prevents.
need for it, right?
Prevent pregnancy.
It prevents,
Yeah.
yes,
That's not.
that's not what this is.
Okay,
Yeah, does that make sense?
makes sense.
Okay. Okay.
I thought I saw a hand just popped up on my screen, but maybe it disappeared.
I don't think anyone's,
Yeah.
Brian?
Correction is here.
Does he have a question?
Wasn't, but it's back.
Representative Chena or Brian, we can't see you, so if you have a question, call Topper. No, just kidding. If you have a question, text me, would be great, and we will.
Thank you. I did accidentally raise my hand and tried to lower it quickly.
Well, Amber is good because she caught it, so.
We turned that thing off.
Okay, so I think we're good to keep going.
So the next section is subsection F. Much of this is language you have already seen. We have made some adjustments based on feedback from the Office of Professional Regulation and the Board of Medical Practice last week, in part because of how we defined healthcare provider. They had some concerns. And then OPR was asking for some clarification around subdivision B here. So I will read what the language will now read and then give a little explanation if necessary.
Okay.
So this would now read, healthcare providers, notwithstanding subsection E of this section or any other law to the contrary, no healthcare provider who is certified, registered, or licensed in Vermont shall be subject to professional disciplinary action by a board or the director, nor shall a board or the director take adverse action on an application for certification, registration, or licensure of a qualified healthcare provider based solely on A, the healthcare provider providing or assisting in the provision of legally protected healthcare activity, or B, a criminal, civil, or disciplinary action in another state against the healthcare provider that is based solely on the provider providing or assisting in the provision of legally protected healthcare activity. So those are clarifying language there. In subdivision 2 definitions, you'll see where we made the most substantive changes here in response to some concerns from OPR and the Board of Medical Practice. So first, healthcare provider would now be defined as a person who provides professional healthcare services to an individual during that individual's medical care, treatment, or confinement. And this is a variation on the definition in 9496, because we're removing that cross-reference to 9496. So we pulled some pieces of that out, but it also had things like the person must be duly authorized to practice in this state. But we wanted to remove you're practicing in this state, you're licensed in this state, because this section deals with people maybe who are coming in from out of state who aren't yet licensed here. And then also in subdivision B, we have a new definition here for healthcare services. Means services for the diagnosis, prevention, treatment, cure, or relief of a physical or mental health condition, including procedures, products, devices, and medications. There's a question about whether healthcare provider includes mental health professions. We usually consider in our statutes that when we're talking about medical care, that does include mental health care. So we did not want to specify that call that out specifically as if to imply that in other places, maybe when we say care, we don't mean mental health care. But in order to give people who had some concerns some peace of mind, I've added healthcare services definition, which includes care that's related to a physical or mental health condition, just to be clear that we're talking about the full scope of care.
All right, let's stop there for a second. Is there any questions on that? It's pretty straightforward. Okay.
Section 7 will look very familiar after what I just went through. I made the same changes in Section 7 that I made in Section 6. So first, that clarification in the first paragraph saying a healthcare provider who is certified, registered, or licensed in Vermont, making those same changes of a criminal, civil, or disciplinary action in another state. And then made those same changes to the definitions of healthcare provider and healthcare services. Oh, yes, sorry.
No, that's okay.
Jen was just specifying these changes around unprofessional conduct for healthcare providers. So subsection F in Section 6 and subsection D in Section 7 have the same changes. I forgot. Section 6, we made those earlier changes. Those are not included in Section 7.
Right.
And once again, Section 7 is those professions that are regulated by the Board of Medical Practice.
Section
We
6.
did consult with the Board of Medical Practice, and they believe they have sufficient authority, or at least David Hurley, without an opportunity to consult with
Right.
others, thought that the board had sufficient authority under their existing unprofessional conduct statutes.
If a provider in Vermont, again, I know we beat this to death.
That's okay.
It's difficult sometimes
Yeah.
to totally understand this.
Why are we taking our time?
Practices in another, or provides services in another state and does something wrong, does something that's wrong, okay? In terms of technically wrong and the patient is hurt in another state. That state then goes back to us. Do we help them then?
Yes, I mean, I think what Michelle was talking to you about yesterday was if something would not be legally protected in Vermont, like it doesn't fall under the category of legally protected healthcare, and in order to fall under legally protected healthcare, you have to be within the standard of care. So if somebody is delivering something that is below the standard of care
Okay,
for what we would consider, appropriate practice here, then Vermont would not, these laws would not shield that provider from the
Okay.
liability in
so
the other
the
state.
keywords are below the standard of care.
In that sense, yes, I mean, in that part of
In
your
other words,
question, right.
they provide an abortion or they provide some service there and it's all botched, it's wrong,
Yep.
it's hurt, the person is injured. So that covers that state is able to then go back or the
That's
person
the
is
patient, right, yeah,
able to
patient
go back.
state. Yes.
Okay.
Right, these shield laws are not shielding substandard
Competence,
care.
right.
Exactly.
But at the same time, the state can't go back and prosecute for doing it at all.
Our state or that state?
The other state. In other words, okay, the patient is hurt, so the patient sues and it's below the standard of care, but the state can't then piggyback on it and say, well, they're not supposed to do this anyway, so we're gonna.
You have to
Just-
look at H89, but I
Yeah.
think once you fall outside of the scope, outside of the standard of care, you kind of lose the protections.
Yeah.
So
Okay,
even
okay, all right,
from
even
having done it in the
that, okay.
first place. So if you're gonna, if a provider is going to be providing
Exposes
service,
himself, yeah.
right, then,
Okay.
they need to be making extra sure, as I'm sure they try to do in all cases, but that they're providing high quality care.
Yeah, okay.
Leslie?
Yeah, I was just thinking about this outside the realm of this topic, but, they amputate the wrong leg. That's below the standard of
Right.
care. They're still going to be exposed.
Right,
And
right.
with discipline, even if they're in another state, their Vermont license would be at risk. They could be sued in this state as well because they have a Vermont license.
I wouldn't say they would be sued in this state, but the Board of Medical Practice or OPR, depending on the profession, could still pursue disciplining that person's license or conditioning or limiting that person's license based on conduct that was out of state.
Okay, so that's what's important. So they could limit someone's license here, even though the conduct is out of state, if they do something like amputate the wrong leg. Sorry.
It's a nightmare. No, like, every time people bring that up, I know it's happened and it drives me nuts.
All right, so the next section starts with findings, which we have not reviewed yet. So I'm going to have whoever's, Cameron, I don't know if this is still your section, actually walk us through the findings. And if whatever you can provide from working on the bill with the Senate as to where they came from and their intent on including them. If you can't answer those questions, we will, I understand that.
So this would, Section 8, as you may recall, adds a new subchapter 11 to Chapter 63, which is the Consumer Protection chapter within Title IX. The first section, 2491, is a new section, Findings and Legislative Intent. Subsection A is Findings. And just to explain, the findings really should be a statement of findings that the legislature has made based on information that you have heard in testimony, received as written testimony or other documentations from witnesses. So the findings you see here were drafted on the Senate side. So it is based on the information that's on the record in Senate Health and Welfare. And so you can compare what your recollection is of what you have seen in this committee and what you have received here with what you are hearing. And I would say if you have any questions where you see that there's something in here that you did not hear or you're not sure the source, then it might be worth connecting with someone from Senate Health and Welfare who could explain their thought process. All right.
Is this piece in statute too? Will this be put in the statute?
Yes, this would be in
The
statute.
findings will actually be in the statute.
Yes.
All right, let's take each one.
So first, the General Assembly finds that 1, centers that seek to counsel clients against abortion, often referred to as crisis pregnancy centers or limited services pregnancy centers, have become common across the country, including in Vermont. Accurate information about the services that a limited services pregnancy center performs, in addition to forthright acknowledgement of its limitations, is essential to enable pregnant individuals in this state to make informed decisions about their care. This includes individuals being informed of whether they are receiving services from a licensed and qualified healthcare provider at a limited services pregnancy center, as this allows individuals to determine if they need to seek medical care elsewhere in order to continue or terminate a pregnancy. Want me to pause after each one?
Yeah, let's probably pause after each one, give everyone a chance to digest it.
Are we commenting on potential further markup?
We can.
I mean, I question on line 17, do we need the word pregnant at the start of line 17? Because I think accurate information about the services is essential to enable individuals in this state to make informed decisions about their care, whether that's pregnancy services or any services.
This is going in a subchapter on limited services pregnancy centers. So I think it may be appropriate to, I mean, while that may be an accurate statement as well, it may make sense to focus in on the particular topic. I think you'll see that theme come up throughout the findings, and maybe it's helpful to revisit the question after we go through, after Ameren finishes going through the findings, because it is all about pregnancy and reproductive care and birth.
So I go ahead.
Well,
No, go ahead.
you go. I just wanted to point out to Daisy's point that we took testimony that they provide other than pregnancy services. They're also providing, purporting to provide STI diagnosis and treatment even though they're not a waived laboratory, but, okay.
So I want to say one thing and then let's flag this and come back to it when we get to the definitions, because in the Pregnancy Service Center definition section, it does say provide services to individuals who are or may be pregnant. So I don't know so let's just flag that, like the may be pregnant is, I'm wondering what that means in relation to the findings, so we can flag that and think about that and come back to it.
Is there any documents about how much wrong information to how much good these pregnancy centers have done? Is there any data on that?
No, because I don't keep any data.
You don't?
I mean, they didn't present any of that on us there. Yeah. Okay, let's go to the second one.
2, although some limited services pregnancy centers openly acknowledge in their advertising on their websites and at their facilities that they neither provide abortions nor refer clients to other providers of abortion services, others provide confusing and misleading information to pregnant individuals contemplating abortion by leading those individuals to believe that their facilities offer abortion services and unbiased counseling. Many limited services pregnancy centers have promoted patently false or biased medical claims about abortion, pregnancy, contraception, and reproductive health care providers.
Thoughts, comments, Leslie, and then Art?
I have seen in other findings where we put in the citation.
So we don't always have citations, right?
Yeah.
I mean, we did it with one bill and that was H210.
Yeah, that's what I'm thinking of.
Yeah.
So I don't know if that has value or not, or rather not.
We don't tend to, no.
Okay.
And I'll just say, I think it does say that some pregnancy centers do acknowledge what they don't do, but others do not. And that is a fact because we had one in here where on the website, it does not explicitly say that they do not. We're gonna finish this finding and then we are gonna take a break because we haven't gone through this. So I wanna make sure everyone's here and they have a meeting with the speaker. So I wanna be cognizant of that. So let's finish discussion on this too and then we'll take a break. Art.
Yeah, I assume that findings have been vetted with you folks, or I don't know if you in this case, but I put a bill in and I had what I thought were findings and they weren't included with the bill because they weren't properly vetted with info, I guess. So I'm just wondering who looks at this and how stuff like what's considered a finding and what type of proof has to be presented to make it accurate.
I would say the findings are.
And I know this isn't your thing.
Right. Are drafted based on what is in the legislative record for the bill.
Okay.
So I would say it might be helpful to go to Senate Health and Welfare's pages and see some of the documents and presentations that were provided. There are slight differences in who testified in that committee versus in this committee. So they may have received different information or presentations than you saw in this committee.
Yeah.
And it might be helpful for you to understand where this language is coming from.
And the Attorney General also worked on these findings and did testify that she was comfortable with them.
She also said there were no complaints. So, yeah, fine.
Any other questions on 2, Daisy?
I guess I'm contemplating, the kind of high level finding back in 1 refers to the how these have become common across the country, including Vermont. And then we kind of have narrowed in the current section that we're looking at in 2. I wonder if we're also kind of starting to think about this as risk mitigation and looking at really protecting folks in Vermont in the case that these things and I'm kind of speaking to what I hear your concern being, if we're not necessarily saying that these specific incidents are happening right now at any specific center in Vermont. We're also protecting people from this potentially becoming a bigger problem here.
But do you really think
And
that?
wait, my question is
Yeah.
not done.
Yeah, okay.
If, do we ever cite, like, or did any witnesses ever cite in Senate Health and Welfare, any national research or anything like that that shows that other national findings show that this is becoming a problem elsewhere?
I believe they did have a witness, a professor from Middlebury College who gave a presentation about research of what is happening across the country. And
That's helpful.
that should be
Thank you.
posted.
Yeah, it should be on their page.
Yep.
We can go.
I'm gonna make a statement, not a question. Excuse me. I don't really care. I don't care what's happening across the country. What I care about is what's happening here. If it's happening across the country, it's starting to happen here, as this says, then that brings it into the Vermont realm. I just want to make sure these statements, in my opinion anyway, are pretty damn harsh. And I want to make sure that those things are actually happening here in Vermont. And I don't know, who drafted this, whether the Attorney General drafted it. I'd like to know that. Who did draft this section? Well, you drafted it, Bob.
I wrote.
But where'd you get the information to put in here?
Let's see, it was a combination of various witnesses who testified in the committee and consultation with the Attorney General's office.
And there were changes made by the committee
Right.
after the first draft who
Yep.
wanted some things, wanted other things adjusted. So I would say it is less important about who specifically drafted it and more important about whether you agree that there is sufficient information to make these findings.
Yeah.
And I guess I got a comment. I care about all people. And Planned Parenthood is probably the number one place to go, and I'd probably suggest that one. But these pregnancy centers are probably helping a lot more people than we think. And I care about those people too. It might have worked for them. It might have been the best thing for them, for their well-being, their mental health, and their physical health. So I just hate to condemn something. I guess my example is, I was on the school board for years. If we had a weak teacher, we didn't fire the teacher. We made that teacher stronger. And I'm hoping this is what we do instead of condemning them.
So I'm going to comment on this one specifically, right? So we are saying some limited service pregnancy centers openly acknowledge in their advertising and on their websites and at their facilities that they neither provide abortions nor refer clients to other providers of abortion services. That is exactly what we want them to do. If they're advertising that they do not do an abortion, let me just step that back. If they are a pregnancy center that does not provide abortion or refer to abortions, that needs to be stated because you have a pregnant woman who may be in crisis going to a center, right? And maybe I agree with you. These people, these centers are helping some people. This is the type of place some people go to get help. And that is fantastic. And I applaud them for doing that work. I really do. But for those who are not telling you that you can't get an abortion, we don't do it here, who are putting on their website, the one abortion center we heard from, when you went to their website, the first thing that came up was all sorts of information about abortion.
Yeah.
It never said, we do not perform or refer abortions. So for me, we heard testimony directly to finding number 2. And I'm not saying we can't change the findings, but we heard testimony directly to number 2. And we're not, I want to be clear, we are not condemning these centers. For those who use them and are helped, thank goodness they are there.
If I, as a healthcare professional, am required to provide evidence-based care and to be forthright and consistent and honest in representing what I do, I think everyone should be as well. We've been held to those standards for a long time, so I think it's time to level the field and make sure that everyone is. That's how I see it.
And Laurie, that's exactly how I feel. That's exactly how I feel. This applies to all, everyone. And what bothers me is this last, many limited service pregnancy centers have promoted patently false or biased medical information, etc.
Well, we can change it.
So I would like, if I could get the word all agencies or all organizations that provide these services are covered by the same thing. That would, to me anyway, it would lessen what I'm considering is the sledgehammer approach on these people.
So because,
Or even if I could name them.
so because, and I think I'm saying the right thing, so correct me if I'm wrong. When you have a facility, a place, an office, provider that is licensed in the state of Vermont.
Yeah.
And part of their scope of practice is abortions or pregnancy care.
Yeah.
When they are licensed,
Yeah.
they have vigorous things they have to follow. And we heard from Planned Parenthood what some of those are.
Non-licensed.
We heard from Vermont. These are not licensed.
Yeah.
So that's, now, do you want to change many limited services pregnancy centers to some limited services pregnancy centers?
Well, you use the word some up above.
So we can change many to some?
Because that to me is a truer statement than many, to me anyway, it's
Right, so we use
it's
some.
above some.
So are those some openly acknowledged, some have not?
That's
Okay, can we change many to some?
You're talking line 6.
Line 6. Does that work for people?
and that calls out the ones that are doing it
Right,
as opposed to just,
a blanket statement. Okay,
Could I ask a question? Going back to page 12, line 9. Can we come up with a word other than fraud? Because the way that's written makes it, again, look like all pregnancy service centers engage in fraud. And to me, that's hurtful to these people. They do great work. I've been involved with them a little bit. It seems to me we could come up with a lot better word than fraud. I don't know what it would be, but something softer than saying fraud.
I'm gonna look to Jen and Ameren for that one, since
Where are you?
it's a title.
Page 12, line 9.
I would like to look at the other subchapters in chapter 63 for consumer protection, because if they are all describing fraud or advertising or, and it could be that it's says something more like pregnancy center services center advertising versus fraud, but let me check to see what is sort of the standard already.
Even if we change the pregnancy service center language to be something broader than, because what it implies, it might not mean it, you can say it doesn't, but what it implies are these pregnancy crisis centers. What it implies, when you see those words, people are gonna think, the faith-based centers that do it for free. That's
Right.
what people are gonna think.
So we're gonna have them look at that. Oh, we have,
Yes, Jen was able to pull it up very quickly. The other subchapters do not seem to list the actual any actual infraction that we're talking about.
Right,
So
there seem to
I
be more
think,
categories of providers.
I think for consistency, it would be fine to remove the word fraud from the subchapter heading.
I'd love to do
Say-
it.
Let's do it.
So then just call Pregnancy Services Center.
Subchapter.
Services centers. I think.
Centers. We would have to
The
change it to
others seem to be minor.
centers. Yes.
So,
But
Mari, hold on. Mari, we're on page 12, subchapter 11, title. We're taking out the word fraud and just, this title is just about pregnancy. This subchapter is about pregnancy service centers. And then in finding 2 on line 6, and I put this with you later too, we're changing many limited services pregnancy centers to some.
That's fine.
Leslie? Sorry, I didn't mean to cut you off, but I wanted to Mari up to speed.
No, I'm trying to decide what I want to say, if I want to say anything, because I'm struggling. Because I know we're going to disagree,
That's fine.
and that's just sort of a fact.
Yeah.
But there are some things, like if you go to the American College of OBGYN, facts are important, medication, abortion reversal is not supported by science. And
So we're talking about this finding, we're talking about this pregnancy
but we're
service
talking
center
about fraud.
fraud.
We're talking
Right.
about fraud.
Okay,
And that if the pregnancy service center is promoting information that is not supported by our professional organizations because the science doesn't support it, then it is fraud.
right.
I just want to say that it's important that we understand in promoting non-scientifically based information that can be considered fraud. Now, if we take it out, I can live with it, but I think we need to be clear that people are being hurt. I know you're worried about people who might be helped, but we also need to worry about people that are being hurt.
Okay, so we're gonna end right there. We're taking fraud out. Thank you, Leslie. We're gonna